Hi there, my name is John Caddy, managing partner of the law firm of Caddy & Gonzalez, and today I am providing you with a lien resolution update on the bankruptcy action involving the Boy Scouts of America. So today is February 16th. Last week, the United States Supreme Court denied cert on a final appeal about an order issued earlier on in this matter. Which means now we're at the point where money will flow into the bankruptcy trust itself, and it's time to talk lien resolution. And so this video is intended for survivors of the Boy Scouts of America and attorneys who represent those survivors to describe lien resolution as it relates to this matter, talk through the three pathways that liens may be resolved, and to provide some clarity about what those liens may look like, the pros and cons of each approach, and at the end of the day, to tell you that myself and my firm are available to help to the extent which you allow us to assist you with regards to these matters. So, first, some basic elementary questions to ask and answer so we make sure we're level setting here, okay? What are governmental healthcare liens and why do they matter in this case? Well, so every allowable claim in this case involves an individual claimant who was injured by being sexually abused in scouting. Many of the claimants, as was revealed during the questionnaire process, sought medical treatment to help heal from those injuries. Some sought treatment for physical injuries, others sought treatment for psychological injuries, and some sought treatment for both. Okay? Some sought treatment while they were still children, and others sought treatment many years after the abuse occurred. What is a healthcare lien? Very simple concept here. Somebody has paid for medical expenses related to this matter. Be it a governmental payer like a Medicare or Medicaid or the VA or Tricare, or it could be a private healthcare plan, a private insurer, maybe an employer-based healthcare plan that paid for this medical or psychological treatment received by claimants. These organizations, these entities may have liens on or claims against any money that the trust is going to pay out to claimants or survivors in this matter. Like I said, some of these payers who are going to assert liens are governmental agencies like Medicare or Medicaid. Other healthcare plans that may assert liens are going to be private health insurers, private companies like Blue Cross Blue Shield or Aetna, or other private healthcare insurance companies. Some of those are going to be governmental plans, meaning they function within federal or state government agencies or have relationships with them. Others are going to be purely governmental plans in and of themselves, okay? So there's a variety of potential healthcare lien holders that need to be considered and addressed before anybody's going to receive any money from the trust, okay? So the trust has mandated rules concerning governmental healthcare liens. All right, so let me explain what that looks like. So with respect to the trust, it has two obligations here. One is it has certain reporting obligations to the Centers for Medicare and Medicaid Services, or CMS for short. Okay? It also has an obligation to ensure that CMS and other potential lien holders are getting reimbursed an appropriate amount of money from the trust as part of the resolution of this bankruptcy action. Okay, and the trust is not going to allow payments to be made to claimants or survivors on allowable claims without having first received a properly signed form or acknowledgement from that claimant that indicates that they're going to choose a certain pathway out of three possible pathways to make sure that these lien holders are getting addressed and paid back, okay? Now, here's something that's super important to remember through this whole process, and it involves private insurer healthcare liens, okay? The trust does not involve itself in any private insurer liens, okay? whether they are purely private liens or whether that lien holder is asserting the recovery as an ERISA plan, an employer-based plan, the trust has nothing to do with that. In fact, the trust will tell you that you may want to seek legal advice about how to identify and resolve any private insurer lien that may exist against your settlement proceeds from the trust. And to the extent that you'd like to receive that legal advice from my office at Caddy & Gonzalez, we're more than happy to assist and counsel you in that kind of way. Because the trust can't give you legal advice. The trust is not a law firm. They're not lawyers that give legal advice. And in fact, most claimants in this case have got their own legal counsel. They've got their own attorney. So if you're represented by counsel and you're a claimant watching this in the Boy Scouts action, you need to talk to your lawyer about which of these three options makes the most sense based on your goals and what you want accomplished, whether that is lowest repayment of liens, quickest ability to get your money, whatever your goal is. You need to talk to your attorney about these three options and pick the one that best suits and meets your goals, okay? Now, if you're a claimant and you don't have counsel, meaning you're not represented by a lawyer, you can still take this advice, figure out which of the three pathways makes the most sense for you, and to the extent that you'd like to talk with us about this in a little more detail with lawyers who specifically focus their legal practice on lien resolution with Medicare, Medicaid, VA, Tricare, private and ERISA liens, etc., we're here for you for that conversation as well, okay? So, as I said, the trust has got two sets of obligations regarding liens held by governmental payers. All right, first, the trust has to make sure that these federal repayment obligations called liens, for ease of reference, okay, are being properly addressed. And then second, the trust must report to Medicare at CMS certain payments to claimants, all right? The trust must make sure liens are properly addressed because under federal and state law and pursuant to the Boy Scouts of America Trust Agreement, the trustee must ensure that certain statutory healthcare liens are properly addressed before issuing further payments to claimants. It's in the trust document, the trust agreement, okay? So these obligations apply to state and federal governmental payers, which may include, but not be limited to, federal Medicare Parts A and B, Medicare Advantage plans under Part C, Medicare prescription drug plans under Part D, the U.S. Department of Veterans Affairs, the VA, the U.S. Department of Defense for Tricare, state Medicaid agencies, and then others. All fall in this bucket of governmental healthcare liens. All right, so that's one. Number two, the trust also has certain reporting obligations, meaning that the trust has to report specifically to Medicare payments that it's making to claimants who are Medicare beneficiaries. So if you're a Medicare beneficiary watching this and you're receiving more than $750 from the trust, that means that Medicare must be notified that you have received money from the trust as part of a settlement of your sexual abuse claim. All right, so the trust is going to report certain information to Medicare if you're a claimant who is Medicare enrolled. Okay, it's a requirement, it's an obligation they have to do. And the trust agreement itself prohibits the trustee from making further distributions to claimants until Medicare's healthcare liens and other similar healthcare liens arising out of your medical care related to the abuse are addressed. So these liens may be addressed in one of two different ways. Okay, number one, by working with the chosen lien resolution administrator through Epiq that the trust is contracted with to assist claimants. And that LRA at Epiq has got two possible paths, which I will describe in a few minutes. The second way that liens could be resolved is without the use of the LRA, and instead handling liens on your own. Whether you are a claimant or you're an attorney representing a claimant, that's going to be the certification path. That's the opt-out provision, not meaning that you can ignore liens, but it means you're going to certify by signing a form that says that you're responsible for addressing all these liens in some way, shape, or form, whether you're doing that yourself, whether you're hiring somebody like myself, Caddy Gonzalez, to help, or somebody else who does this type of work. There is a pathway to allow that to happen. Now, important to understand that the failure to properly resolve certain governmental healthcare liens can result in negative consequences for both the claimant as well as the attorney representing the claimant as well as the trust. All right? These negative consequences may include, but not be limited to, denial of future health care benefits under certain programs like Medicare or Medicaid, the filing of an action against you and or the trust to collect amounts owed for liens that failed to get reimbursed, and the trust incurring fines and penalties which will reduce overall claimant recoveries, okay? Now, some of you might be thinking, well, can't the trust just pay me now and let me deal with the governmental healthcare liens later? And the answer to that is no, they can't, because of the legal requirements described and because of the obligations set forth within the trust agreement. The trust can't issue any further payments on a claim until your governmental healthcare lien obligations are addressed. Now, addressed is different than finalized, okay? We're going to talk more about that nuance here in a few minutes. Others of you might be asking, well, what if I don't have any liens? Can I just get my money? Well, if you've ever had treatment from a certain agency, for example, Medicare may think that you have Medicare liens. You may say that you used only Medicare to treat conditions that had nothing to do with the sexual abuse that you suffered. But Medicare may take a different position, and that difference has to get resolved. You may end up prevailing on that issue in the end, but in order to do that, you have to work things through with Medicare or reach some other understanding with Medicare. So that's why we still have to worry about this issue right now, front and center, and picking one of these three options, okay? So the next question to ask and answer, how will the trust reserve money for payment of my liens and fees, okay? Now this might get a little bit complicated, so bear with me. If you choose option A or B of the three options available, the trust will reserve funds, meaning they will hold funds back from future payments on your allowed claim as a lien reserve to cover your lien expenses and fees. So, assuming the supplemental distribution is 4% of the claimant's allowed claim amount, the amount of the lien reserve will be 2% of the claimant's allowed claim amount. Here's an example. The second distribution from the trust will be 4% of the allowed claim amount. All right? The allowed claim amount is $100,000. And claimant has already received 1.5% as an initial distribution, totaling $1,500. They elect option A for lien resolution and complete the required forms. The claim is being processed for supplemental distribution. Claimant A will receive $2,000 of their $4,000 supplemental distribution, which is the full distribution minus the lien reserve. The trust is holding back the other $2,000, or that 2% of their allowed claim amount, for the lien reserve. As soon as the trust's LRA, lien resolution administrator, determines the amounts owed on liens by the claimant, the lien reserve will then be released to the claimant, less the applicable lien repayment values and LRA fees. If a valid lien is identified, it would be paid by that LRA out of the lien reserve, and the LRA's fees for that work will also be paid out of the lien reserve. How long the lien reserve will be held by the trust depends on each claimant's unique lien profile, but the LRA will work diligently to try to resolve these issues as quickly as possible. Now, if the claimant elected option C, meaning certification, they're going to handle that themselves, there is no holdback for the lien reserve, and the claimant would receive the entire 4% supplemental distribution from the trust on the $100,000 allowed claim, or $4,000. However, and this is worth noting, claimant A would then be responsible for identifying what medical bills Medicare paid, determining which of those medical bills, if any, relate to the underlying abuse claim, And then paying Medicare for related medical expenses paid by Medicare per federal law out of the monies distributed to claimant A by the trust. The net amount kept by the claimant, meaning the amount of the trust distributions less any lien repayments and related fees, can't be estimated by the trust, as the claimant and their counsel, if applicable, are responsible for resolving and repaying any liens independently of the trust. The claimant would then be responsible for paying any fees charged by their counsel or other provider for the lien resolution work. Now, let's talk about these three options in more detail, okay? And first question, how can I address my governmental healthcare liens so I can get paid by the trust? Question that everyone's asking now, right? You can either choose to work with the trust's lien resolution administrator to resolve your governmental healthcare liens, or you can choose to do it yourself. That's your choice, okay? If you choose to work with the lien resolution administrator, there's two options that you can choose from. If you choose to resolve the liens on your own, there's one option, and you'll be required to sign a form saying that the amount you may have to pay to resolve identified governmental healthcare liens plus all the administrative expenses, counsel fees, penalties, and other repercussions of your decision are your responsibility, not the trust's responsibility. So you have three options to choose from: two involving the lien resolution administrator from the trust, and one that certifies that you, not the trust, will be responsible for resolving all of your own liens without help from the trust. Before the trust can make any further payment on your claim, you must elect one of these three governmental healthcare lien resolution options. And once you make your election, it cannot be changed. Here are the three options. Option A, and we'll talk about these in more detail. Option A is the LRA Global pathway that involves the lien resolution administrator. Option B is the LRA Traditional pathway, which also involves the lien resolution administrator. Option C is the certification pathway, where the claimant is 100% responsible for lien resolution, which does not involve the LRA, right? So let's explain each of these one by one. Option A, the LRA Global pathway, where the trust is responsible to resolve all governmental healthcare liens, including Global Medicare Resolution Agreement. In option A here, the trust seeks to have you pay a fixed amount to resolve any and all liens of governmental payers arising from your scouting sexual abuse claim. These liens relate to medical expenses that a governmental payer paid, pays, or may still pay for care you received or will receive in the future related to your scouting sexual abuse claim. The trust is seeking, quote, global resolution for certain federal agencies. So attempting to reach an overall agreement, and it already has an overall global agreement in place with Medicare, and it's actively working on finalizing agreements of a similar manner with other federal agencies as we speak, okay? A global resolution means a resolution in which every claimant who was or is an enrolled beneficiary of a healthcare agency pays the same negotiated amount of money to resolve any reimbursement obligations the claimant may owe to that agency related to a scouting sexual abuse claim. The global resolution for Medicare ensures that the federal government will not impose a lien on any future scouting abuse related health care you may receive that may be covered by that agency. This global resolution for Medicare provides that every claimant who was or is a Medicare beneficiary will pay either $58.99 or $177.87, depending on the claimant's type of healthcare coverage. This amount covers any Medicare liens from past healthcare expenses and prohibits any future Medicare liens against the trust award for future Medicare-covered healthcare expenses related to the scouting abuse. Currently, the Trust Lien Resolution Administrator is in negotiations seeking global resolution with certain other federal agencies, including the U.S. Department of Veterans Affairs and the U.S. Department of Defense, Defense Health Agency, but those negotiations are ongoing. So if you choose option A, The LRA will include the resolution of your governmental healthcare liens in all global agreements that the LRA reaches with these federal agencies. You likely will have to pay additional amounts if you're a beneficiary of these agencies. The additional amounts are not known at this time. Certain other agencies, such as state Medicaid agencies, resolve liens on a claimant-specific level. For example, this means that if you were a Medicaid beneficiary, different than Medicare, if you were a Medicaid beneficiary in one or more states, the LRA will work with each state's Medicaid agency or its representatives to determine if they are asserting liens against your recovery in this case. As part of the process, the LRA seeks agreement with state Medicaid agencies to limit their recovery amounts based on cap and offset agreements where claims are identified and audited to ensure relatedness to the underlying abuse. You will likely have to pay additional amounts if you're a beneficiary of these agencies. Those additional amounts are not known at this time. Now, you might be asking, well, are there any other costs associated with Option A? And the answer is yes. In addition to the governmental healthcare lien repayment amounts discussed above, you must pay a fee for the work the LRA does to negotiate the global agreements and resolve these liens. The LRA fees for Option A range from $65 on the low end to $865 or more, depending on your healthcare coverage with governmental payers and the number of liens identified. So, that is a summary of Option A, the LRA Global Pathway. Now, let's talk about Option B, the LRA Traditional Pathway. Now, Option B is exactly the same as Option A with one major exception. And that exception is that in Option B, resolving your Medicare liens is not handled through the global resolution process. Instead, resolving your Medicare liens is handled in a traditional process, which means the LRA will seek data about your treatments you received and will negotiate with Medicare through its recovery agent to arrive at a fair Medicare lien amount based on the care you received that was paid for by Medicare. If you were in the global Medicare program under Option A, your maximum payment for Medicare Parts A and B liens would be $177.87. If you choose Option B, where your Medicare liens are resolved in the traditional program, your payment for Medicare Parts A and B liens might be less than $177.87. But it also might be more than $177.87. In Option A, the global resolution of Medicare liens includes resolution for any future health care covered by Medicare related to your scouting sexual abuse. In Option B, the traditional Medicare resolution program will be used, and it does not cover future health care. This means that if you choose Option B and seek treatment relating to the abuse after the LRA resolves your past claims, Medicare may refuse to pay for treatment or may stop your Medicare coverage until you repay Medicare for the cost of that future treatment. There are ways to address that future Medicare piece separate and apart from this program. If you have any questions about that, happy to talk you through those, as that's a service that my firm provides with what's called a Medicare Set-Aside Legal Opinion, or MSA Legal Opinion for short. Now, also note that the LRA fees for Option B are higher than they are for Option A, and it generally takes longer to reach resolution in Option B than it does for Option A. But beyond that, everything else is exactly the same for Option A versus Option B. Okay? That's the LRA traditional pathway. Now, let's talk about Option C, called the certification pathway. And this is the pathway where the claimant is responsible for lien resolution on their own. Okay? So under this option, the claimant elects to resolve all governmental healthcare liens independently, and the claimant and claimant's counsel agree to reimburse the trust if the trust incurs any liability from a lien holder with a federal recovery right related to a claimant's failure to resolve any governmental healthcare lien obligations. The claimant and claimant's counsel are responsible for identifying, resolving, and paying all applicable governmental healthcare liens consistent with the terms of the federal court order that authorize the LRA to enter into data exchanges with governmental payers. This is important to think about. The failure to properly resolve liens, including Medicare-related liens, may result in enforcement actions by governmental agencies, including collection efforts and potential denial of future benefits if done incorrectly. Here's the timing and cost impact to option C. So the claim will proceed to payment once the required forms are returned to the trust and the trust has reviewed the forms for completeness. Then, at that point, no LRF fees will be deducted from trust distributions. However, your law firm may assess costs or other fees to you related to their efforts to resolve governmental healthcare liens on your behalf. Under option C, the claimant bears full responsibility for paying any liens from the settlement proceeds paid by the trust to the claimant or claimant's counsel, if applicable, and addressing any future lien-related issues. The claimant bears full responsibility for paying all fees charged to the claimant by the claimant's counsel or by any other provider who the claimant engages to obtain help in the lien resolution process. So that's option C, the certification pathway, where the claimant or counsel go on their own. Now, you've got to make a choice between option A, B, or C at the end of the day. And you have to mark your election form indicating which option you choose. And if this form is not completed and returned to the trust, then the claim cannot proceed to payment. So you have to make a choice between option A, B, or C. All right, because governmental healthcare lien obligations can have long-term financial and healthcare consequences, claimants are strongly encouraged to review this information carefully and consult with legal counsel or some other knowledgeable individual before making their election. Let's start to wrap up our time here and discuss how your lien resolution choice affects payment in your case, because it has a direct effect on how much money you're going to receive from the trust and when you receive it. All right. Choosing option A provides you with predictability. Certain governmental healthcare lien repayments, including Medicare, are capped at a fixed amount, and lien resolution is typically faster. Lien resolution fees and lien payments are deducted from your award. Option B, on the other hand, it may reduce your Medicare repayment if Medicare claims aren't there, if Medicare didn't make any payment for you. But it does often take significantly longer and may result in a higher overall deduction in fees. Option B still provides certainty for you if you're identified as a current beneficiary of Tricare or a veteran through global repayment agreements being finalized. The LRA is working hard to ensure that if you were, for example, identified by more than one federal agency as having received healthcare benefits triggering more than one repayment amount, those combined amounts will be capped. The amounts to be paid to the VA and the Department of Defense are still not known, but negotiations are ongoing. Choosing option C may result in a faster payment from the trust without a lien reserve being held back by the trust. But you're fully responsible for resolving and paying any governmental healthcare liens and any associated cost for such resolution. You may wish to consult your attorney to determine if you will be charged fees and costs for their work related to governmental healthcare liens. Option C gets you more money from the trust faster, without a doubt. But there's no guarantee that a federal or state agency will not seek repayment from you if liens are found but not repaid. And you may pay substantial fees to your counsel or other providers for the lien resolution work that they do. Because governmental healthcare lien obligations can affect both your settlement payment and your future healthcare benefits, you should carefully review these options and consult with your attorney before making your decision. So option A, LRA Global pathway. Option B, LRA traditional pathway. And option C, certification, where claimant agrees to handle all lien resolution on their own terms. Obviously, there's benefits to each of the three pathways. There are drawbacks to each of the three pathways. And you, as a claimant, as a survivor of this sexual abuse you sustained, you need to think critically about what your goals are. If your goal is to have certainty with respect to the lien resolution process, options A or B may be more preferable to choose. Option A, the global route, provides certainty, but you might end up paying back more money than what you may owe as a part of that agreement on the global deal. Option B, the traditional pathway, means you're going to pay what you owe, but it's going to take longer to figure out that number, thus longer to get paid. Option C means you get paid fast once you submit the certification and any of the forms required by the trust in order to disperse, but then handling the liens is on you. That may be a good thing, that may be a bad thing, depending on your situation. But these are all decisions that need to be thought through critically and discussed with an attorney if you are represented by counsel, or if you're not represented by counsel, thought through by yourself on your own about what your goals are, consulting with those loved ones that you trust with respect to this decision. Okay? At the end of the day, what Caddy and Gonzalez does is we resolve healthcare liens around the country, both governmental and private and ERISA liens. And to that point, option A, B, or C, as addressed here by the trust, is all about governmental healthcare liens. The trust in none of these options is addressing non-governmental liens for private health insurance, for ERISA plans, etc. Okay? Those are also liens that you're going to need to address in some way, shape, or form that the trust is not responsible for and that the LRA is not going to be handling. So no matter what option you pick on your form, you will have to address, on your own terms, private and ERISA liens. And we would love to help you with that exercise, in addition to the governmental health liens also if you choose option C. We are here to help. It's work that my firm does day in and day out all the time for folks around the country, and would be happy to consult with you and work with you and negotiate these liens down and vigorously fight for the minimum amount of lien repayments that you owe in order to maximize the ultimate settlement proceeds that you'll be receiving from the trust at the end of the day in your pocket. So with that, again, my name is John Caddy. I'm the managing partner of Caddy & Gonzalez. We are a lien resolution, Medicare compliance, and preservation of government benefit law firm that works across the country with survivors like you, with attorneys like you, to help minimize lien repayment obligations, maximize net settlement proceeds, and protect our clients' future access to Medicare and Medicaid benefits. If you have any questions, feel free to reach out. You can email us at info@caddylaw.com, or you can visit our firm's website at caddylaw.com for more information. Till next time.